Welcome back. In this segment, we're going to take a look at the case against President Trump from a legal perspective. Former federal prosecutor Roland Riopelle will join us in just a moment. But first, there's a look back at some of the key moments from yesterday's impeachment hearing, and also some solid points, in my opinion, as well as some metaphors here made by Democratic witness Pamela Karlan that helps put what the president did into perspective.
Imagine living in a part of Louisiana or Texas that's prone to devastating hurricanes and flooding. What would you think if you lived there and your governor asked for a meeting with the president to discuss getting disaster aid that Congress has provided for? What would you think if that president said, I would like you to do us a favor. I'll meet with you and I'll send the disaster relief once you brand my opponent a criminal.
And we also wanted to play one of the key objections that Democrats are going to have to answer here, certainly assuming this goes to Senate trial. Now, this came from the Republicans' witness yesterday, Jonathan Turley.
Impeachments have to be based on proof, not presumptions. That's the problem when you move towards impeachment on this abbreviated schedule that has not been explained to me. Why you want to set the record for the fastest impeachment. Fast is not good for impeachment. Narrow, fast impeachments have failed.
And then you get to the process, especially once impeachment reaches the Senate. Now, the White House, they're already coordinating strategy with Senate Republicans. The sense is they may go for a more prolonged trial in the Senate. This morning, the president tweeted he wanted Adam Schiff, Nancy Pelosi, and the Bidens, father and son, to testify. And if the Chief Justice decides to play ball, he may just get his wish. Now, that approach, which is reportedly gaining steam, would have the Senate, not Chief Justice John Roberts, making all the big calls on impeachment. This comes from Time magazine, quote, senators could decide in real time the rules through a series of motions offered from the floor of the Senate. Senators don't expect Supreme Court Chief Justice John Roberts, who would preside over a Senate trial, to take an activist role. McConnell suggests that Roberts would be a quote-unquote passive participant and put the motions to votes among senators who would need 51 votes to adopt an idea put forward from the Senate floor. Now, if that happens, not only would Trump be able to call basically who he'd want as a witness, but it becomes that much less likely we would ever hear from any of the key figures under oath. And with that, let's turn it over to good friend to the program, former federal prosecutor Roland Riopelle. And Roland, I know you, just like me, believe the case has been made, and that the president, with all the compelling testimony, particularly that we heard through the intel hearings, they can place him there, they can put motive to it. We know the money was held up. We know, even from the redacted version of the transcript, what he was after. To that end, though, what if Pelosi goes out tomorrow and she, in effect, calls the Republicans' bluff? Jonathan Turley, I may not agree with it, but he makes the point to say, what's the hurry? To that end, and I just spoke to a guy who gave me the political perspective why Democrats want to get this thing over and done with, but his point, my argument would be, Pelosi goes, all right, you know what? We heard you, Jonathan Turley. We hear other Republicans saying that this is a rush. Well, let's give you what you want. We're going to ask the Supreme Court right now. This is the list of witnesses that we've subpoenaed that have chosen not to attend, not to testify under oath. This is a list of either factual information that will be relevant to this trial, evidence that we want to see, let alone let's expedite the ruling on the tax returns, whatever other pending cases are in front of the high court that obviously could impact this. Let's do this. Get it all done by the end of February, because there's no greater national import than these particular cases, and then we will have an expedited trial in the Senate. Over to you. What if they did that and put it on the table? I still haven't heard a compelling argument. Maybe it won't change any minds, but this canard that we're really doing this half-baked without hearing all the facts and giving the president his opportunity to present his case, at least we put that to bed.
You know, Richard, the best way to think of this, for me as a former prosecutor, is to think of it the way the prosecution thinks of an indictment, and to think of the impeachment process that we're in the middle of now as the equivalent of a grand jury proceeding. The way the rules work for a prosecutor is you are permitted to seek an indictment at any point where you believe you have evidence that will prove beyond a reasonable doubt the guilt of the defendant. You don't need to wait until every last bit of evidence is gathered before indicting a defendant, because, and that's particularly true in a situation where there is ongoing criminality. When you've got the goods, you should bring a charge and stop the defendant in his tracks. Here, we have plenty of evidence that Mr. Trump has violated the campaign finance laws, done illegal acts in an attempt to give himself a benefit in the last election and in the coming election. And this is an ongoing crime. He's a one-man crime wave. It would be my view as a congressperson that Congress, like a prosecutor confronted with a defendant like this, has a duty to bring the charges it believes it can prove now to try to stop this. If the Senate decides to use whatever legislative legerdemain it wishes to allow this one-man crime wave to continue, that's on them.
We understand that the articles of impeachment will be plural. We expect they're going to be abuse of power, bribery will be there, and also obstruction of both Congress and obstruction of justice. There's different strategies saying, you know, you should narrowcast this thing, go after one charge. The idea is giving a buffet of them. Maybe there's a political rationale that some people, especially in some toss-up districts, can vote no on some, yes on others, etc. What do you think of the strategy of having 4 charges instead of a single one?
I do think there's got to be at least 2. I think the Ukraine situation, whether you call it a bribe, an extortion, or something else, a violation of the campaign finance laws, that's got to be one. The president's consistent obstructive conduct in connection with Congress's investigation has got to be another. I do think you want to keep it narrow and probably focus it almost exclusively, if not exclusively, on the Ukraine situation and the investigation of that situation. I don't think 4 is too many. I wouldn't do 10. I think that is too many. I think you should keep it narrow and clean.
This, I have to say, is more out of hope than probably out of reality. But is there a chance that Justice Roberts, could wear the white hat here and, in the end of the day, make some decisions and obviously can't appeal above him? He'll be the presiding judge in this trial, where he'll compel certain witnesses to come in. He'll make sure that the ancillary side shows that maybe some members would want it to be won't, displace what should be a sober trial. Or, and I had a professor from Georgetown last night, Con Loxford, says, historically, that's not the role of the Chief Justice. Originally, it was going to be the Vice President, but everyone understood the conflicts of interest the Vice President would have presiding over the trial. He's really there just calling balls and strikes, not to have an active role. What could Roberts do, and what do you think he will do here?
Well, he's going to have to decide applications made by the 2 sides in the case. So if someone is demanding that John Bolton, for example, testify and demanding that the court decide that issue immediately, I think Justice Roberts will decide an issue like that. I think he does not, he's an institutionalist. I think he'll want to be involved in an appropriate way, right, in a vigorous way, and protect the Supreme Court's reputation by doing that.
Now, you've got a fascinating theory I've yet to hear from anyone else as to what might be crawling around in Trump's brain right now as it relates to timeline and also concerns and pardons, and more specifically, not ones that he'll be handing out, but ones that he may want.
Right. This may be part of the motivation for why Congress wants to proceed quickly with impeachment, because the pardon clause in Section 2 of Article 2 of the Constitution provides that the President shall have the power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. Now, it's unclear exactly what that clause means, but certainly it is arguable that what that clause means is that if an article of impeachment is returned against a person, that person cannot, if he is pardoned, he cannot be pardoned thereafter. So that would explain why Richard Nixon chose to resign the presidency before articles of impeachment were actually returned against him. That gave Vice President, then President Ford, the ability to pardon him.
Interesting theory. Roland, my friend, as always, thank you for the time. I appreciate it.
Pleasure to be with you, Richard.
All right, coming up next on RFL, not impeachment. Trump news you may have missed, from food stamps to NATO to even Hillary Clinton on Howard Stern. Donald Trump's going to love this segment. It's coming up next.